Welcome to our webinar on contact tracing privacy development. We're excited to present to you the first of Venable's Privacy Law and Policy webinar series, and later on in this series we will have future ones on EdTech and children's technology, as well as political ads. So for today we have one on contact tracing privacy development. Today you'll be hearing from three members of Venable's privacy group on this emerging topic. Myself, Tara Sugiyama-Patashnik, a partner with our privacy group, as well as Kelly DeMarcus-Basti, a partner in the privacy group, and Adriana Beach, an associate with our privacy group. In today's webinar, we will be providing you with an overview of the contact tracing landscape, beginning with what we mean when we say contact tracing. It's a fairly ubiquitous term now, and it's probably hard for us to remember that even a few months ago, many of us didn't know what the term contact tracing meant. So to level set, we'll provide you with a definition of that so that we're all talking from the same lexicon. Having set this baseline of understanding of contact tracing, we'll segue into a discussion of some of the privacy considerations that contact tracing raises. And then, in addition to the privacy considerations, an underlying theme that we encourage all of you to think about during this webinar are how such considerations ought to intersect with public health considerations. This is a privacy webinar. However, public health considerations are also part of the conversation. And to this point, I would like to refer to an opinion column that I came across a while ago by three Duke University professors entitled "Lessons from 9/11 Can Help Build Better Contact Tracing App." And it is an opinion article that set forth the opinion that quote unquote, strong privacy protections can be built around public health priorities rather than the other way around. This will allow the public to better appreciate the health benefits that come with the privacy sacrifices we will all need to make. And so I think that you'll hear that as we're talking about all of these privacy considerations, there's a balancing act that members of Congress, the public, businesses, we're all taking those into consideration as we figure out how to navigate this new landscape. Then the next topic that we'll turn to is the existing patchwork of laws, regulations, and existing industry guidance that impact contact tracing. And all of these laws and regulations and guidance exist at the federal level, the state level, and with industry, but many of them were created not specific to the kind of contact tracing apps and solutions that we're seeing today. And then we will round this out with an examination of what federal legislators are doing and how they're responding to what we're seeing today, as well as legislation that is being proposed. With that, I'll turn it over to my colleague, Kelly DeMarcus-Basti.
Thank you, Tara. So we're going to start by defining what we're talking about when we're discussing contact tracing. At a very basic level, contact tracing is a tool that's used to prevent the spread of infectious disease by identifying people who have cases and any contacts of theirs who may have been exposed, and then working with this population to interrupt disease transmission. For COVID, this includes asking people with confirmed cases to isolate themselves, identifying their contacts, and asking those contacts to quarantine for a period of time that's either sufficient to get test results or for symptoms to emerge. So identifying, notifying, and monitoring people who came into close contact with a COVID case while they were infectious is the goal of contact tracing. It is a fact-finding exercise. The old-fashioned way, and we shouldn't say old-fashioned because it's a route that a lot of government agencies are relying on today, is to conduct paper interviews of infected persons, then interview and notify any of their contacts. It may involve posting general information, like information that an infected person traveled on a certain bus or attended a particular church service. COVID is unique in that a lot of governments, health departments, and employers are looking at technology, most commonly through mobile apps, to do this work for them. And we have great examples of how this has worked in practice from countries that encountered the coronavirus pandemic before the U.S. did. For example, China launched an app that takes phone tracking to the extreme by monitoring citizen location and their purchases in order to gauge their risk level and restrict their movements further. South Korea, India, Iceland, and certain U.S. states are using phone location data to monitor the spread of COVID. This really underscores that the heart of contact tracing is personal data collection, which of course intersects with privacy, our topic today. So we wanted to set the table by highlighting some of the privacy and other related considerations that may be implicated by contact tracing. The first are related, of course, to sensitive data gathering, and this is sensitive data related to people's health, to their in-person physical contacts, to their location and movements. This is a type of information that in the commercial context is either legally required or, as a matter of guidance and best practice, subject to robust notice, affirmative opt-in consent from consumers, various platform controls, and other privacy settings that give users heightened transparency and control over the collection and use of such data. Both the contact tracing apps that are being developed and the employers and others who will rely on this data that these apps might collect have to wrestle with the fact that giving control to users in this context undermines the efficacy of the app. Thus, the current paradigms and consumer expectations are upended in the COVID context. Next, an important aspect of contact tracing is not simply collection of the data, but how the data is used. It can be used, and often is used, for example, to pinpoint hotspots or places where people are gathering in contravention of social distancing rules. But the use of this data has to consider whether these rules are being applied fairly, whether they take into effect the systemic racial discrimination and bias of which we've all become aware. Does this data collection exacerbate the type of discriminatory policing and employment practices which we are unfortunately all too familiar with? And then what about more theoretic concerns? The right to privacy, to be anonymous, is a very valuable one. Workers are generally afforded certain privacy rights, even in the context of their workplace. Your employer doesn't usually get to know what you do with your day off, for example. This, we'll call it right to anonymity now, has to be balanced against public safety and public health concerns. We also wanted to talk for a moment about the type of technology. GPS can be used to identify potential hotspots and indicate who has been exposed, but GPS is not precise enough to identify one-to-one contacts. There's been a lot of interest and uptick in using Bluetooth handshakes to identify these in-person connections. This would be when a device emits a Bluetooth signal short range and then contacts with a Bluetooth signal emitted from another device. There's a potential exposure then. A notification can be triggered to the affected individuals. These are, of course, smartphone technologies, and these technologies in some ways are not as promising as hoped. They rely heavily on user adoption, which is a challenge both because of our current political climate in an environment where neighboring states and jurisdictions might apply different standards. Unfortunately, also, parts of the U.S. still struggle with smartphone adoption and broadband penetration and coverage. So we have to consider other alternatives such as wearables. For example, the NBA, who are currently quarantining in their bubble in Orlando, has offered players a smart ring that tracks temperature, sleep, heart, and respiratory rate. This is an area where we see growth potential. Wearable technologies have already been deployed by employers for worker safety, and in certain industries or settings, adoption of a wearable may have fewer barriers to entry than use of a smartphone app. But transparency is harder in the wearable context, so certainly something to consider. Lastly, what's the role for industry? Due to the speed of the pandemic and the federal government's response, large players like Apple and Google have largely stepped into the vacuum by providing technology upon which local government apps can rely. But is that a role that we want industry to fill? So I'm going to start off by talking about today's legal landscape. Everything we've been discussing has to be considered against the backdrop of existing laws which were not designed for this moment. The U.S.'s sectoral approach to privacy means that any employer or app developer unfortunately can't look to a single law to set the relevant standard. Instead, there's a multitude of federal and state laws that have to be considered. Later in the presentation, we'll discuss some of the legislative proposals that would specifically govern contact tracing at the federal and state level. But at this moment in time, general privacy laws that may have some impact here are enforced by the Federal Trade Commission, or the FTC, in the states, usually through the Attorney General, who are the primary privacy regulators at the state level. Industry standards also have a role to play, and we will talk about each of them. So, starting on the federal side, as you probably know, the FTC is the primary federal regulator for privacy. It uses its authority under Section 5 to protect consumers from unfair or deceptive acts or practices, and it applies that authority in the privacy context. While the FTC has not brought a case or issued guidance specific to contact tracing, general privacy guidance would apply here. Specifically, apps or other connected technologies will need to have privacy policies. Those have to be complete and accurate. To the extent that a particular app would materially exceed in terms of data collection, use, or disclosure, if it would exceed materially what was disclosed to consumers, it could be found to be unfair or deceptive. Moreover, the FTC has issued guidance on consent in the terms of staff reports on mobile privacy disclosures and general consumer privacy. For example, the FTC staff report from 2013 on mobile privacy disclosures says that apps should obtain affirmative express consent just before the point of collection when allowing access to sensitive content, including geolocation information, through an API. According to the FTC staff report from 2012, companies should obtain affirmative express consent before collecting sensitive data for certain purposes, and that would include health data and also precise location. How the FTC would apply this guidance in the context of contact tracing, where you simply can't have folks opt out of sensitive data collection, is not clear. The FTC also has an extensive body of cases on data security, which stand for the general proposition that personal data must be subject to reasonable data security safeguards that are appropriate for the type of data that's being secured. For example, the FTC has cited storing sensitive information without encryption or storing it in clear, readable text without appropriate access controls as the subject of multiple enforcement actions. Those kinds of practices may be per se not reasonable data security in FTC parlance. There are numerous other components of what consists of reasonable data security that have emerged from FTC enforcement actions. Because of the sensitive data at issue here, employing data security that meets FTC and state standard will be absolutely crucial. There's also relevant guidance from the FTC, again in the form of staff reports or similar non-binding guidance or through enforcement actions on topics like de-identification and the collection and use of precise location data. We would also add that FTC guidance on data disclosure does not speak to the kinds of questions that are relevant here. For example, employers wrestle with whether to disclose data to local public health authorities, how much information to disclose, what to disclose to other coworkers in the workplace so they can understand their own exposure and risk. There's just not a lot of guidance here on the federal level. There is extensive FTC guidance on unlawful data disclosure and exposure, but it often deals with things like providing data to third parties and contravention of consumer expectations. So looking towards the guidance around how to set consumer expectations in your particular context might be relevant to the questions that we're talking about today. Outside of the FTC's Section 5 authority, there are other federal sectoral privacy laws that might apply. The most important of these is Hipaa, the Health Information Portability and Accountability Act, specifically Hipaa's privacy rule. Hipaa only applies to covered entities, which includes healthcare providers and health plans, but it could apply to certain large employers that, for example, maintain their own health plans. So in a general commercial context, Hipaa is unlikely to apply, but certainly large companies may be a covered entity for Hipaa purposes. We also see the use of Hipaa in other contexts or kind of a piggybacking on Hipaa. For example, the DC Code would allow DC's mayor to establish databases that must be Hipaa compliant. So this is one example of piggybacking on existing Hipaa standards in a situation where Hipaa doesn't directly apply. There's other sectoral laws that might apply in certain limited circumstances. We wanted to highlight the Children's Online Privacy Protection Act, or COPPA, which applies to the knowing collection of personal information from kids under age 13. Data collection there requires verifiable parental consent, which is a pretty high consent standard. And certainly as schools are looking to potentially bringing small children back in the fall, these are questions that they might have to wrestle with. There are other sectoral specific privacy laws like Gramm-Leach-Bliley, which applies to financial institutions, or FERPA, which also applies to schools. And they're unlikely to apply in this context, but if you are an entity that's regulated by a sectoral specific law like this, certainly you should verify that it doesn't apply before proceeding with contact tracing or extensive data collection related to contact tracing. There's also a large body of state and federal laws that regard access to things like stored communications and that govern recording of audio, commonly known as the wiretapping laws. So if that kind of data collection is relevant to your app, there may be 50 state laws to look at there, depending on your jurisdiction. Now to move into the state discussion, I'm going to turn it over to my colleague, Adriana Beach.
Thank you. As Kelly mentioned, there are a number of state laws and regulations that may be within scope for contact tracing. Specifically, there are commercial privacy policy laws in California, Delaware, and Nevada. And what these do is they require operators of websites and online services to have online privacy policies. The titles are CalAPA, DelAPA, and in Maine, the Act to Protect the Privacy of Online Consumer Information. These laws require online privacy policies to provide information regarding how the commercial entity collects and uses information, and it should be publicly accessible. In California, there is an additional privacy law which became effective January 1 of this year, the California Consumer Privacy Act, and that law places additional requirements on the kinds of information that are required to be within a privacy policy. Specifically, CCPA requires that the notice obligations include the disclosures of the type of information that was collected and the purposes for which they were collected. It requires entities to provide notice before using the collected information if they're going to use such information for additional purposes. It also requires that the notice link appear in the download page within an app, which is pretty important given the fact that a lot of contact tracing is being conducted on mobile applications. And then the CCPA also requires just-in-time notices for collection of personal information if the consumer would not reasonably expect a specific purpose of that use of information. In addition to the privacy policy requirements, California through the CCPA and Maine through its Privacy Act provides individuals with rights regarding their data for those respective statutes. So in California, the CCPA requires that individuals have the right to access, delete, and opt out of the sale of their personal information. It's important to note that the definition within the CCPA and Maine and other state privacy laws are very broad so that they include the kinds of data that we're talking about today. And so this is important as individuals may have certain rights with respect to contact tracing information. In Maine, the privacy law provides consumers to give express and affirmative consent to internet service providers before they use, disclose, sell, or permit access to the customer's personal information. And then similarly to CCPA, Nevada provides the right to opt out of the sale of personal information. Importantly, there is a proposed bill right now in California, AB 1782, that specifically addresses contact tracing. The title of this proposed bill is Technology-Assisted Contact Tracing, Public Accountability and Consent Terms Act, and that's quite a mouthful, so there is an acronym for it, the Tact Act. And this proposed bill takes the definition of personal information from the CCPA. So again, it is broad. What the Tact Act requires is that a business or public health entity that's offering technology-assisted contact tracing, so TACT, to allow individuals to consent at any time, but it also allows them to revoke their consent at any time as well. For businesses that are not affiliated with a public health entity, the proposed bill requires that the business disclose this to individuals upon soliciting information from them or providing them with a service, so i.e. before actually conducting contact tracing. Both businesses and public health entities under this proposed bill are required to issue a public report at least once every 90 days. So there is a reporting component to this. And the report must include the number of individuals whose personal information was collected, used, or disclosed using contact tracing. And also the report must include the categories of information and the recipients of information if the business or the public health entity shared this information with another third party. The proposed bill also prohibits discrimination based on information collected through contact tracing, and it also provides similar rights to individuals as they do under the CCPA. So this bill has set forth that individuals will have the right to access, correct, or delete information that's collected from contact tracing. Lastly and importantly, this proposed bill also requires businesses and public health entities to delete any personal information that is collected pursuant to contact tracing within 60 days from the time of collection. So in addition to these notice provisions and individual rights, data security laws are also important and set the tone for this legislative landscape for contact tracing. There are at least 25 states that have laws that require private sector entities to implement and maintain reasonable security procedures and practices, and those practices and procedures should be appropriate to the nature of the information collected in order to protect the personal information from any type of unauthorized access, destruction, use, modification, or disclosure. Additionally, each state has a data breach notification law that would apply in the event of a data breach. So those security provisions would also be applicable. To add to Kelly's point, because a lot of the contact tracing is occurring on cell phones, whether it be through Bluetooth or GPS technology, App Store guidelines also play an important part in contact tracing. So Apple and Google require that app developers take appropriate steps to protect the data from storage, from any unauthorized access to the storage, and also require app developers to securely transmit the data using modern cryptography. In addition, the Apple and Google exposure notification systems, they have been serving as the basis for multiple apps developed by healthcare authorities for purposes of contact tracing. So the Agents feature, it potentially helps protect users from any type of unauthorized use or access to it based on how the system has been structured. It uses Bluetooth to track the proximity rather than GPS track locations, and it's said to be that it's because it's more precise and more effective. Additional features also include the fact that it enables app users and Android phones to interface with one another, and also can help assist public health authorities develop apps that also use the same system to help track COVID. The implementation occurs across various apps, and the system should be able to assist authorities in the United States, but also potentially abroad. It's important to note as well that the system is opt-in, even though Apple and Google are co-developing their own contact tracing interfaces independently, there is some overlap in terms of keeping privacy and security at top of mind. Now, moving over to influential industry standards, I'll give it back to you, Kelly.
Thanks. Before we left the topic of industry codes, we also wanted to highlight that the Digital Advertising Alliance's self-regulatory principles, which are a leading industry code of conduct, would require consent for the collection, use, and transfer of precise location data. Generally applies to companies that adhere to the DAA principles, but it's something that may be seen in contract standards or provisions related to DAA principles or other industry guidance. So just to sum up where we are in the current legal landscape, at present, there are no federal or state laws that restrict the use of location tracking to assist with contact tracing. Relevant statutes and case law would arrive primarily in the employment context or the criminal law kind of wiretap context. However, the FTC's General Privacy and Security Authority is relevant here. We have no indication that the nature of the pandemic or the necessity for contact tracing will relieve companies of certain privacy and security obligations that are enforced by the FTC. Federal guidance that may bear on certain aspects of location tracking and other aspects of contact tracing thus plays a role here. State laws are also influential, especially in terms of data security, consent for certain data collection, like medical information, and how these requirements apply in contexts like the employment context. Both Apple and Google impose restrictions relating to location data and contact tracing, and these large industry players and their practices are also extremely influential in this context. So the end result here is the lack of a unifying standard, which is consistent with the U.S.'s general pandemic response to date. Now I'll turn over to my colleague, Tara Potashnik, for more on pending legislation which may upend the status quo.
Thanks, Kelly. I think that you're being very optimistic thinking that federal legislation at this point can upend the status quo, but I'll return to that in a moment. So turning to the U.S. Congress, how is our federal government and specifically the Congress responding with the development of legislation and examining whether or not that there's federal legislation that our country can put forth? And so one of the many ways that Congress has always done this is by holding hearings, sending letters to companies, and introducing legislation. But in the middle of a pandemic, of course, it's a little bit hard to go about holding hearings in the same way that we would go about that in normal times. And so what that means is that after many started to go into shutdown mode, shutting down various states and in the DC metro area, I think about it as Pi Day back on March 14th or so. That's when many areas started to shut down, and then the Congress started to look at how they could hold virtual hearings. And what they came up with in the Senate Commerce Committee, which is the committee with primary jurisdiction over many data privacy matters, is they developed this notion of a paper hearing. So what this was on April 9th, the Senate Commerce Committee convened virtually. Everything was done on paper, so perhaps not even really on virtual. It was everything was submitted online, and they held a hearing entitled "Enlisting Big Data in the Fight Against Coronavirus." And it was convened by Chairman Roger Wicker of Mississippi and Ranking Member Maria Cantwell. And they had 6 witnesses testify on paper, and they were representatives from the academic community, consumer groups, industry associations, as well as some technology providers. And committee members had until the end of the day on April 9th to submit their questions to the witnesses to answer. And then those witnesses had 96 business hours to submit their responses to the committee. And what that resulted in a few days later on April 15th was the questions that were sent to the witnesses all totaled over 100 pages. So these witnesses were pouring through 100 pages of questions, and there were 362 member questions that were posed. And the questions covered a range of topics touching upon federal privacy and the intersection of contact tracing. And some of those themes that were posed to these witnesses included, one, the development of federal privacy legislation for which each witness indicated support. Not often that we hear various interest groups across the spectrum calling for legislation, but this was one where every single witness indicated their support for such legislation. They discussed specific privacy law proposals, as well as Privacy for America is an organization that has been developing a new paradigm for privacy legislation, and that was raised as a topic of consideration by several of the witnesses. As Kelly mentioned, Hipaa is one of those laws that applies to in the health privacy context, and that was raised. Additionally, the topic of potential government-developed apps aimed at tracking COVID-19 was discussed, how government entities ought to be using data and whether there should be restrictions there. Seventh topic was how we go about balancing privacy and COVID-19 tracking and health considerations. The eighth topic was the anonymization, aggregation, and de-identification of data. Those are all steps that are often viewed as ways to help provide services while providing a certain amount of privacy for citizens. Companies' data practices were also examined. The role of online advertising in a pandemic was explored. The notion of whether there should be purpose limitations on data use was brought up. How data affects underrepresented communities was raised. That was an item that Kelly spoke about at the beginning of this webinar as a topic that's of enormous importance during this time. Data security, specific data controls, and then again, as we see, attempts to how we should open schools again, children's privacy was also raised. So that was back on April 9th and April 15th. And then following this paper hearing, we began to see a slew of letters, and members of Congress will frequently send letters. So the first letter that came about, this was all about mid-April. So on April 21st, Senator Josh Hawley of Missouri wrote a letter to Google and Apple CEOs requesting that they ensure that consumer privacy be incorporated into the efforts that they were developing to mitigate the coronavirus pandemic. And this was with respect to the guidelines that Kelly and Adriana mentioned that Apple and Google have developed. Also on April 21st, 16 senators sent a letter to the CDC and the Department of Health and Human Services urging that the agencies establish tracing mechanisms to assist with the mitigation of the coronavirus pandemic. Then lastly, among the letters that I will highlight for you all was a letter from Senator Ed Markey of Massachusetts. On April 22nd, he sent a letter to Vice President Pence outlining principles for a national contact tracing plan. And in his outline of principles, he included such principles for consideration as opting in for contact tracing, which is debatable whether or not that's the approach that we all ought to be taking. That is a position that Senator Markey advocated for. He also spoke about transparency and related to data collection and processing in the COVID context, data security obligations, and accountability for data misuse and other violations, and lastly, data minimization and data use limitations. So while those letters are going out and these paper hearings, or really one paper hearing was being held, then our members of Congress began to develop legislation and to introduce legislation pertaining to the coronavirus, and some of them touched upon contact tracing. And the kinds of bills that we saw, the federal legislative bills that came out initially at the beginning of April, seemed to focus on in four areas. One was calling for the establishment of a commission to review the United States response to COVID-19. This is kind of similar to what we saw in the 9/11 context. Another group of bills focused on the establishment of surveillance programs on viral diseases. A third group focused on safeguards for how states ought to reopen. And then a fourth group focused on health entities funding for COVID-19, including funding for contact tracing. But of course, what you all are most interested in today and why you came to this webinar is to learn about the intersection of contact tracing and privacy. So now we'll turn to three bills. Well, some of them have companion bills, so it's a little bit more than 3, but 3 primary ones that were introduced later on, beginning at the end of April and May and June, that really were introduced at the intersection of privacy and contact tracing. So on April 30th, it was announced that Senator Wicker and a few other members of Congress would be introducing a bill entitled the Consumer Data Protection Act. And that was actually introduced on May 7th and referred to the Senate Commerce Committee. Then on May 14th, Senator Blumenthal on the Senate side and Representative Eshoo on the House side introduced the Public Health Emergency Privacy Act, which was S3749 and HR 6866. This bill was referred to the Senate Health, Education, Labor, and Pensions Committee on the Senate side and Energy and Commerce on the House side. Then on June 1st, Senators Cantwell and Cassidy introduced S3861, the Exposure Notification Privacy Act. This bill had an interesting introduction into the Congress. It was originally referred to the Senate Health, Education, Labor, Pensions Committee, and then there was what we understand a discussion with the parliamentarian, the congressional parliamentarian, and then the bill was subsequently moved over to the Senate Commerce Committee, where Senator Cantwell is the ranking member. So that was a little bit of politics going on in the background for there. So a little bit about what's in these bills. So with Wicker's bill, which was the Consumer Data Protection Act, and one of the first ones to be introduced amongst this trio of bills, we saw that the bill would mandate that before collecting, processing, or transferring data as part of COVID-19 mitigation efforts, that companies will be required to obtain individuals' affirmative express consent. And as you may recall from what I said about Senator Markey and opt-in, that's sort of that line of thinking, that this would be an opt-in approach. The bill would direct companies to inform consumers how their data is handled, retained, and shared, and among other provisions would require companies to enable consumers to opt out of collection, which is the opposite of opt-in, processing and sharing of health and location data, publish transparency reports describing their data practices with respect to COVID-19 mitigation, delete or de-identify personally identifiable information after such data is no longer being used for COVID-19 mitigation purposes. And the bill would also establish data security and minimization standards for PII collected by companies. And it also included definitions for aggregated and de-identified. Later on, we had, as I mentioned, the introduction of the Public Health Emergency Privacy Act. And this was by Senators Blumenthal and Warner on the Senate side, and then Representatives Eshoo and Schakowsky on the House side. And their bill would require that companies provide consumers with the ability to correct emergency health data, companies to establish purpose limitations and data security provisions, obtain affirmative express user consent for the collection, use, or disclosure of data, and the publication of a public report by companies that collect data from more than 100,000 consumers regarding the type of data collected and purposes. And fifth, data deletion would be required after a certain period of time. It was further noted in this bill that data collected for public health reasons may not be used for advertising and e-commerce purposes, among other purposes. The FTC and the state AG enforcement authority was included, and this bill also envisioned including a private right of action. This bill also would not preempt existing laws. And then on June 1st, Senator Maria Cantwell the ranking member of the Senate Commerce Committee. Oh, and I should go back a few to mention that Wicker's bill, he was the first one to introduce this bill. He's the chairman of the Senate Commerce Committee. I think I failed to mention that. So now going from the chairman's bill and then talking about the Blumenthal bill, and then moving on to Senator Maria Cantwell's bill with Cassidy, and Cantwell is the ranking member of the Senate Commerce Committee. And they introduced a bill, and also Klobuchar was also on that bill as well. And they introduced a bill that would mandate that COVID-19 exposure notification apps be opt-in only for consumers, abide by data use limitations, including a prohibition against using data about consumers for commercial purposes, enable individuals to delete information from exposure notification systems at any point in time, and require that COVID-19 exposure notification apps feature data security safeguards, and protect against potential discrimination towards consumers stemming from data shared with exposure notification systems. Now you're probably all wondering, it's quite confusing when you hear what's the difference between all of these bills that have been introduced. So I'll go back through that more at a thematic level and talk about how these bills are similar and different along some of these privacy topics and how they would impact the use of commercial data, for example, and other provisions. So along the lines of, on the topic of de-identification, the Cantwell proposal defines aggregate data, but it does not include a definition for de-identified data. And the concept of de-identified data is alluded to in the definition of covered data, which includes information that is linked or reasonably linkable to any individual or device, linked or reasonably linkable to an individual, but it's not specifically called out for or accepted from covered data in the Cantwell proposal. And when you look to the Blumenthal-Eschue proposal, those bills define neither aggregate data nor de-identified data. And the Wicker proposal defines both types of data. On the topic of deletion, under Cantwell, the data deletion provisions do not address aggregation or de-identification as a way to satisfy the deletion requirement that's envisioned in the bill, whereas the Wicker proposal provides that covered entities can de-identify for deletion, and the Blumenthal-Eschue proposal would allow for data to be rendered not linkable to an individual. On the topic of compliance with legal obligations, the Cantwell proposal permits data transfers comply with the establishment, exercise, or defense of a legal claim, but does not generally address the need to retain data required to meet legal obligations. There's also no exception to the deletion requirement for these purposes. Both the Wicker and the Blumenthal-Eschue proposals contain carve-outs for compliance with legal obligations. Just to make sure that you all are still with me, I'm not sure if we did this before, but I want to share that the CLE code word is tracing. Now back to the topics of these contact tracing bills. A fourth theme is the scope of the automated exposure notification service and service provider requirements. Under the Cantwell proposal, the automated exposure notification service captures services that are designed in part or in full specifically to be used for or marketed for the purpose of notifying individuals potential exposure to COVID-19. This term specifically excludes service providers that provide this technology to facilitate an automated exposure notification service, and when the service provider does not use the technology itself as such a service. Additionally, there's a bit of a lack of clarity on whether dual purpose data falls outside the scope of the proposal, and same with to the extent that commercial service is not designed in full or in part to be used for contact tracing, but is used to offer a notification service. So that's an area where clarification could be provided. It's also a little bit unclear under the Cantwell proposal whether covered entities can leverage commercial data for use in these services. Data collected through the service cannot be used for commercial purposes. We don't know if that means whether commercial data collected for another purpose could not be used in these systems. Service providers are also required to report noncompliance to either the automated exposure notification service provider or public health authorities when they have actual knowledge of that noncompliance, which creates liability for service providers that could result in disincentivizing participation. On the topic of breach notification, the Cantwell proposal contains breach notification requirements for covered data and does not preempt state and federal breach notification laws already on the books. And these other proposals don't include a breach notification requirement. Turning to non-discrimination, the Cantwell bill proposes prohibiting requiring the denial of entry to a public accommodation as defined by the ADA if an individual does not participate in an app, and there is no exception for employee or employer relationships to this prohibition. The Wicker proposal has an employee exemption, but the Blumenthal and Eschew proposal does not. And lastly, on the topic of preemption, the Cantwell bill does not preempt state laws. Wicker bill does preempt laws, and the Blumenthal and Eschew bill does not preempt laws. So that is a brief run through of these COVID bills that have an intersection with privacy. And you're probably wondering, okay, so now we've got these bills, what's our solution? Is the Congress going to come through? And what are the legislative prospects? Well, in the last legislative package that went through last month, the House HEROES Act did not address these bills. On the topic of contact tracing, there were some funds provided, I think, by the CDC to pay for the old-fashioned contact tracing that Kelly talked about, the paper tracing, that having people go out doing that, not the automated versions of that. And then most recently this week, the Senate came back into session on July 20th, and everybody is waiting for Senator McConnell's CV4 bill, the fourth relief package, to be introduced. And we were all expecting that to be introduced earlier today, but now there's some debate about that, and that may be delayed until Monday. But it's currently, our intelligence is telling us that there's no mention of these contact tracing or privacy bills in the McConnell package currently, from what we understand. So what that means is that if this legislation is going to pass, it will likely need to pass as individual bills, not as part of the COVID Relief Bill number 4, or as part of another legislative vehicle. In terms of which bills could move forward out of the ones that we've talked about today, Senator Wicker, the chairman of the Senate Commerce Committee, has a hold on anything pertaining to contact tracing and privacy that's not going through his committee. So the Blumenthal-Eschew-Schakowsky bill, which is over in the Senate Health Committee, Senator Wicker, it said, has a hold on that bill. And we've also heard that the House Democrats are not particularly enamored with the Eschew-Schakowsky proposal, and that Pallone may not move that bill. So the prospects for that bill, for the Blumenthal and Eschew bill, seem to be a little bit lower. Advocacy efforts continue by many entities to continue, despite it's unclear what the path forward is for this proposed legislation, but there's still enormous opportunities for input on the privacy provisions of these bills. One of those efforts that's currently working on providing input on the privacy provisions is an organization called Privacy for America. And if you're interested in that, we encourage you to reach out to Privacy for America to see how you can contribute to that effort as well, both on privacy legislation and contact tracing, or at least the intersection of that. The takeaways from today. Contact tracing apps are a powerful evolution in the way we can treat pandemics in a way that we weren't able to do before. Before, we were limited to non-automated ways of going about contact tracing. And we really have powerful creative opportunities that we can pursue during this pandemic to try to resolve this as a society. But how we as a society navigate this we all need to balance privacy considerations and public health concerns and seeing how we balance those. And the way we go about balancing these considerations will contribute ultimately to the quality and the effectiveness of the systems that we develop. And the current patchwork of evolving regulations and laws and industry guidelines are something that all of us who want to create creative solutions to address this will always need to have in the back of our mind. How do we develop these solutions while also navigating the evolving legal landscape? And as I mentioned, the federal legislation is, the prospects of that passing is still TBD, but it's something that many of us are still working on. And with that, we will turn to questions. All right, so it seems that my colleague Kelly we're just running through the questions right now that we're receiving. So Kelly, I'll turn it over to you to address some of the questions that have come in. And I know that we are coming up upon the hour. So for those questions that we don't respond to online or with you all now, we will reach back out to you and we can connect with you then. So Kelly, I will turn it over to you. Thank you.
Okay. I think, thanks, Tara. Just scrolling through the questions that have come in. Here's one. Can Hipaa become applicable to companies when it previously didn't due to the collection of temperature or other contact tracing related information? And then the question continues, if a company has some type of self-funded healthcare plan, they may be subject to Hipaa. Is that accurate? The answer to that part of the question is yes, that self-funded healthcare plans may make an employer a covered entity subject to Hipaa. But the first part of the question, which, does Hipaa become applicable to a company when it previously didn't due to the collection of temperature or other information? The answer is no. So the threshold for Hipaa applicability is still you have to be a covered entity. An employer that has a self-funded healthcare plan can be a covered entity. That's kind of one part of the equation, but you can't become subject to Hipaa merely by collecting health information for contact tracing purposes. Unless you already satisfy one of the threshold criteria. Another question here. You were asked, for companies who are creating their own contact tracing solution for employees coming back to work, what features are a must-have? The versions that I've seen and talked with various companies about collect some very basic health information. Do you have a cough, shortness of breath? What is your temperature? Kind of the questions I think we've all become accustomed to answering in our day-to-day life. I think from a privacy perspective, as we said, a lot of the guidance that applies to sensitive data collection may be unclear as to how it applies in this context. But for a privacy protective posture, we certainly recommend collecting the minimum amount of data necessary and keeping it for the shortest amount of time needed for your purposes. So something like a temperature reading is only as, it's good sort of in the moment, and really it's not helpful even 24 hours later because of how quickly symptoms can come or go. So to the extent you're collecting data that might be sensitive, certainly we recommend that it's discarded effectively immediately. And, transparency and communication with your workforce, I think, is always recommended. I think we have time for one more, and Tara, this one might be for you. It's asking specifically about regulations on data collection in Senator Wicker's bill, and does it apply to data collection outside of the context of contact tracing? Oh, did we lose Tara? We might have lost her. Oh, okay. I think we have one more. Any recommended resources to keep track of legal information or changes pertaining to contact tracing? Yeah, this is a tough one because there are so many different sources to look at. I know if you're a member of IAPP, which is the International Association of Privacy Professionals, I think they have some resources that are aggregating some of these sources. Otherwise, I think it's I'm not aware of any central repository that's tracking this more broadly. Sorry.
Although, if you would like to be on Venable's COVID-19 Privacy Digest, please reach out to us and we will add you to our weekly digest as well for articles.
Of course, that's right. Venable has a resource. It's a good reminder, Tara. Thanks. I think that is the end of the questions.
Well, thank you all for joining us. And again, if you all missed, if we woke you to sleep in the middle of that, the word is tracing. So thank you for joining us this afternoon. And we hope that you will join our upcoming webinars on EdTech and children's privacy and political ads. Thank you.